recording this lecture on regulation of cyberspace. So basically with this we are going back to a particular time period when throughout the world there was an issue with regard to whether you can regulate the cyberspace or not. So in the same parlance, if you look at today's current scenario, we see that India as a country and also other particular uh, globally dominating countries, basically, they are also facing a certain issue with regard to regulation of cyberspace in the form of dark web or the metaverse. So uh, people are, or the governments are struggling with regulating the dark web or unlawful activities that are happening in the dark web due to anonymity, and also the activities that are committed in the metaverse. So probably whatever is going on in their mind is the same thing that was going on in the legislators and in the minds of the governments when we first encountered cyberspace. So now, speaking about cyberspace, when we were trying to regulate cyberspace, there was particularly two questions that would be bothering the legislators. The first question was whether we could apply the traditional laws or the traditional process of rule making to the particular cyberspace, as in to the individuals who were working in that cyberspace. And the second question was whether we needed a new law that is in particular to the environment altogether. So, with these two questions, as are laid down in the screen before you, the two school of thoughts also emerged with regard to regulation of cyberspace. So the first school stated that probably you couldn't regulate cyberspace because they were failing to apply the traditional laws into the cyber environment. And the second school of thought differed from that opinion and said that no, we can regulate cyberspace, just that we need to have customized rules with regard to that cyberspace. Now, why was the first school facing all of that issue? Why was the first school feeling that we couldn't regulate cyberspace? Because their approach was with regard to the first question, as in how does the rule of law affect the individuals within the environment over which this law is effective. So they were trying to apply all the traditional laws to the cyber environment. So when we talk about, for example, the traditional laws, like as you can see, we have mentioned about the Theft Act, Section 1 of the Theft Act, mentioned that Theft Act would only cover tangible goods, physical goods, and we were only trying to regulate any sort of unlawful activity that was done over the physical goods. For example, physical goods are stolen, and we were also trying to control the activities of a corporeal individual, as in a person who you can actually catch hold of, right? So that is why, because when we look into the definition of theft act, the problem is, will then this theft act be applicable to virtual property? So property that can be stolen and also acquired online, right? So will that be eligible enough, or will that be equipped enough to be applicable in the digital world? The answer at that point of time was no. So of course, because of this problem, the major lawmakers, basically the lawmakers felt that probably the traditional legal rules were not equipped and they had to be re-evaluated in order to apply them to the digital environment. Now, the major problem, therefore, with regard to applying the traditional rules to the cyber environment was the fact that there was no boundary, right? So, these interactions, when we talk about the internet, were majorly cross-border transactions, and when we talk about cross-border transactions, it is very difficult to regulate it, right? Because a person sitting in US might impact somebody in India. A person sitting in US might actually commit phishing and take away the money that is sitting in a bank in India. So that's very difficult. There is no border control over the internet, right? So these are cross-border offenses. So when we or contraventions basically. So that was the first problem, that our traditional laws were particularly subjected to border controls, because we had territorial jurisdiction, we had jurisdictional issues, and our laws are only applicable to acts committed within India, and uh, it was particularly subjected to border controls, except for a few exceptions. And of course, the second point was that we needed physicality of goods, as in goods had to be physically present, had to be tangible, right? So, and of course, it was the laws were only applicable to a person who is also having his jurisdictional presence within India, right? His like the corporeal body had to be there to imprison, or probably a registered place of business in India. So all of that was necessary, having a physical, like a physical body to imprison, and also the fact that it had to be applied only over the only over a jurisdictional boundary, and both of them were not existing in cyberspace. There was no jurisdictional boundary, and also there was no corporeal body to imprison. So of course this created the problem for the lawmakers, and for a long period of time, the question was not about which law should be applied to cyberspace. Rather, the question was more of whether we can regulate cyberspace or not. So they had completely given up on regulating cyberspace. And this led to the school of thought that we can see over here, that is the school of cyberlibertarianism. Now, this was propounded by John Perry Barlow, and he was a poet and a political activist of his times, and he had propagated with regard to the Declaration of Independence of Cyberspace. And what he basically said was that cyberspace is a separate sovereign space, and here the real world laws and the real world governments are inapplicable. And it was a very powerful challenge to all the law enforcement bodies and the lawmakers as well. According to him, what he wanted to state was that, see, when we talk about the digital environment, there is no corporate body to imprison. There is hardly a border in the cyberspace. So it's very similar to what we have in the real world. That is, for example, if a person crosses the border, uh, they would enter into a territory where they think that they cannot be regulated, and it's the same with regard to cyberspace, right? If a person steps from the traditional space and logs onto the internet, they go into a separate sovereign space where they think that they can't be regulated. So that was the ideology in this school of thought, where they felt that the lack of physicality found in the digital environment makes it a very different and a very difficult choice, whereby the physical world laws, the real world laws, are completely inapplicable. So these are the two arguments behind it, right? That there is no border. I believe that there is no border between that in the cyberspace particularly, and it's a separate sovereign space where people could roam about free without any barrier, without any challenge, and also there is no corporeal body to imprison. So of course, it's a separate sovereign space and it cannot be regulated. That was the argument in this school of thought. Now, of course, if one school of thought is going to say that we can't regulate cyberspace, there has to be another school of thought which would say that we probably can regulate cyberspace. Now, what does this particular school of thought state? Um Cyber paternalism school of thought, as that has been laid down over here, it had a very different point of view. According to cyber paternalism school of thought, they essentially assume that the cyber environment itself is tailor-made. It has been made by a human being, right? It's man-made, and because of the fact that it is man-made, it is not possible that you cannot regulate it, right? And that was the whole idea. The idea is that probably because it's man-made, you can regulate it, just that there has to be a new source of rule making, right? Probably the traditional laws do not apply to it, but other laws will be applicable. So it was propounded by Professor Joel Riedenberg of Fordham Law School, who stated that, of course, there is disintegration of territorial borders as observed in the cyber libertarian school of thought, but that does not mean that you cannot regulate cyberspace. There are new sources of rules, there are new models of rules that are applicable in the cyberspace. And he targeted two particular uh, sources of rulemaking. The first was with regard to contractual agreements between internet service providers. Now, this is being kind of it is being implemented right now. When you see the intermediaries regulation 2021, we see that the liabilities imposed on internet intermediaries are being increased slowly but steadily, right? So intermediaries are being increasingly made liable, and because of their increasing liability, their contracts will have a major role in regulating unlawful activities. Second, the thing that he stated was that we need to look at the network architecture, because the architecture is man-made and it itself is responsible for regulating unlawful activity of the internet. For example, it's very similar to a lock that is there in front of a door. So the larger the lock, the difficult it is to break it open. And the same thing here. So for example, earlier uh, documents could be freely copied and distributed over the internet, right? People could download them freely, and it was amounting to copyright infringement. But there was this new thing that came, and which was called the password protected documents. So there were technological protection measures, right, that were used in order to protect those documents from being infringed, from their copyright being infringed. And that is, of course, that is changing the architecture of the document in a way in which people will not be able to commit copyright infringement. So the point is that the law is in place, but still piracy was there. People were downloading the copies. There was copyright infringement. So the law was failing to regulate it, but we invented another way. We invented technological protection measures. We invented password protected documents, by virtue of which we regulated that infringement of copyright. And that is what the argument of uh, cyberpaternalism school of thought was, that we can regulate cyberspace. It's a man-made world, and of course it can be regulated. And that led to the school of that led to the conceptualization of the lex informatica, uh, whereby it stated that the fault rulemaking and the source of the fault rulemaking was the technology developers and the social processes through which the customary usage of the technology evolves, and the fact that uh, it is being made by a man, it makes it regulable. And that was the entire idea. Now, this idea was later on redeveloped by Professor Lawrence Lessig, whereby he gave four modalities of regulation, as in, along with law, there were other three modalities through which you could regulate any unlawful activity in the cyberspace. So, as you can see over here, along with law, there are three other particular modality. Law, of course, being whatever the statute lays down, which basically governs your choice of actions, and it can constrain the choices of actions that an individual have. The other modalities being social norms, criticism or ostracism. If somebody is wanting to commit theft, they first fear with regard to the amount of ostracism or the criticism that they would receive from their own relatives, from the society at large. and that is why they probably think twice about committing it. So it's regulating their acts, right? That's the second modality. Third modality being market constraint. Now, what is a market constraint? Let's go back to the example of copyright infringement. So, as you know that earlier you could download MP3 music files freely over the internet, right? There were certain websites like Netscape where you could download MP3 music files freely, right? So that was doing what? That was committing copyright infringement, right? But basically the law was still in place. The law stated that you could not download or you cannot distribute copyright infringing MP3 music files, and that's against the law. You cannot commit copyright infringement, but people were still doing it. Piracy is still a very breeding market. But even though we couldn't regulate it through the particular idea of law, what we did was we changed the market. We introduced the market for iTunes, we introduced the market for Savan, Wing, all of these apps through which you could see a licensed version of that music. So you did not need to download it, but it was still there on your phone. So people shifted. It was cheap, some of them were free, so people shifted their approach to that. So they changed the market for that particular copyright infringing MP3 music files. And architecture, that was a last particular modality. This we have already discussed. What is a modality of architecture? You change the architecture of the file. You make it password protected, so people can't access it. So this was particularly the four modality. So this slide basically discusses about how copyright infringement was happening. As you could download it from BitTorrent and it was easily available. Copyright infringement could be easily done, but the market changed. So yes, these are the four other modalities of regulations, like along with law, three other modalities by virtue of which you could regulate cyberspace. So it is basically saying that if law is not able to regulate it, there are other means to regulate it, right? So somehow, according to the school of cyberpaternalism, what we can see is they propounded that okay, if you can't regulate it by one means, you probably can by virtue of other, right? So you just need to identify that. So that's it with regard to the particular school of cyber libertarianism and cyberpaternalism, and with regard to regulation of cyberspace. Thank you so much.